Good morning, good afternoon, good evening in Dubai, depending on your location. Please join in the struggle to liberate our people from the contraption by liking and sharing our videos. Let me give you the updates. FG gives Supreme Court 13 grounds to block IPOB leader Nnamdi Kanu's release. That's Nigerian government working against the release of the leader of the IPOB, Nnamdi Kanu. They are working against his release in illegal direction. Illegality is becoming legal in Nigeria. That has been the trend, particularly since 2015. Abracadabra, judicial rascality. The federal government has approved that. And now you see, they has added 9 grounds of appeal to the 4 it hurriedly filed last year to block the release of the IPOB leader. Okay? Now, you recall that the Court of Appeal in Abuja ordered Mr. Kanu's release. Said Maazi should be released from the custody of the State Security Services after dismissing the charges against him in October last year. That's 2022. Now, the treasonable felony and terrorism charges related to Maazi Nnamdi Kanu's campaigns for the Southeast or the Eastern region, to exit Nigeria and other neighboring places as the independent Republic of Biafra. Those treasonable felony and terrorism charges has been quashed by the Court of Appeal, Abuja Division. Now, Maazi Nnamdi Kanu has fled Nigeria around September 2017, pausing his trial that started in 2015. He was abducted in Kenya and brought back to Nigeria in extraordinary rendition means. It was very controversial in June 2021. Of course, the Federal High Court in Omaya have given their judgment on that, talking about Maazi Nnamdi Kanu's, movement out of Nigeria in 2017, that the federal government is referring to, that he absconded. The Federal High Court said he didn't abscond, rather he fled for his life because of assassination attempt made on him in his home, Afaruku Maya. Now let me give you the grants of the federal government. Grant 1. The government said the Court of Appeal erred in law by allegedly failing to consider the relevant provisions of the Administration of Criminal Justice Act 2015, a law that regulates criminal proceedings in federal courts. They cited Section 221 of the ACJA. The government argued that the Jumai Sankey-led 5-member panel of the Court of Appeal failed to give legal effect to the law which stops courts from entertaining preliminary objections to charges at an interlocutory stage. Grant 2. The government queried the appellate court's decision on the basis that it refused to be bound by established judicial precedent laid down by the Supreme Court on the mode of entry of defendant charged with the commission of an offense. Now, they cited the case of Patrick Njovens and others versus the state in 1973. He said the appellate court's decision was a clear departure from the precedent set by the apex court. Grant 3. On another ground, the prosecution said the appeal court was wrong to have relied heavily on international legal instruments and cases decided from foreign jurisdictions in arriving at its decision freeing Maazi Nnamdi Kanu. Now it contended that the court's reliance on foreign laws like the Organization of African Union Charter on Prevention and Combating of Terrorism, as well as the African Charter on Human and People's Rights, was at the expense of laws governing criminal procedure in Nigeria. Now, Grant 4. The government complained of being denied a fair hearing by the Court of Appeal. It said the appellate court justices failed to determine the competence of Maazi Nnamdi Kanu's preliminary objection to the competence of the charges against him, thereby denying the government the right to fair hearing. Now, Grant 5. Contesting the court's order releasing Mr. or Mazi Nnamdi Kanu, the government argued that the appellate court erred when it held that the Federal High Court lacked jurisdiction to try the IPOB leader because of his extraordinary rendition from Kenya. There was no evidence, according to the federal government, led by Mazi Nnamdi Kanu, before the court of first instance and the court below to show how he was allegedly abducted and rendered to Nigeria. That's what the government is saying. They said there was no evidence, but they were directed to produce and tell the world, not just Nigerians, how Mazi Nnamdi Kanu was extraordinary rendition to Nigeria. What happened in Kenya? Let them tell us what transpired. How he was abducted in Kenya and brought back to Nigeria in such a controversial circumstance. Up until this moment, Malami and his co-hosts have not explained how Mazi Nnamdi Kanu was brought back to Nigeria in such controversial circumstances. And now let's go further to ground 6. The government canvassed this ground to argue that the Court of Appeal did not consider the issues that predated Mazi Nnamdi Kanu's extraordinary rendition. They said the government said the IPOB leader was standing trial for the commission of offenses of conspiracy, treasonable felony, and terrorism before his escape. It said the appellate court failed to provide justice for the state, whose laws and normative values were broken, and also provided no justice to the victims of Mazi Nnamdi Kanu's criminal act. Ground 7. The government said the Court of Appeal was wrong when it failed to consider that it was the illegality of Mr. Kanu or Mazi Nnamdi Kanu's act of jumping bail and his refusal to make himself available for trial that necessitated his return to Nigeria. Now let's go to ground 8. The government posited that the Jumai Sankey-led panel of the Court of Appeal erred in law and occasioned grave injustice on the appellant, that's government, when it held that the extraordinary rendition of Mazi Nnamdi Kanu robbed the trial court of the jurisdiction to entertain the charges pending before the court, even before the IPOB leader jumped bail and absconded. That's according to the federal government. Ground 9. It is the contention of the prosecution that the Court of Appeal acted without jurisdiction when they entertained Mazi Nnamdi Kanu's appeal. They said decision of the trial court having been made without jurisdiction in breach of section 3962 of the ACJA. Ground 10. The government argued that the justices of the Court of Appeal erred in law when they relied on Mazi Nnamdi Kanu's affidavit in support of his preliminary objection to conclude that the respondent was illegally brought back to Nigeria. Ground 11. The government also said the appellate court was wrong when it held that the failure of the appellate court to respond to some paragraphs of the affidavit in support of Mazi Nnamdi Kanu's preliminary objection amounts to the appellant conceding to the facts therein. Ground 12. The government challenged the Court of Appeal jurisdiction to detain Mazi Nnamdi Kanu's interlocutory appeal, which was filed without leave of the Federal High Court. It said the Federal High Court's decision, which Mazi Nnamdi Kanu appealed against, was interlocutory, that is, filed in the course of trial. Ground 13 and last. On this ground, the government argued that the justices of the Court of Appeal were wrong when they relied on the alleged non-compliance of the federal government with the provisions of the Extradition Act in concluding that Mazi Nnamdi Kanu was unlawfully brought into Nigeria, and therefore the trial court lacked jurisdiction to continue his trial. Now, in the court filing signed by the Director of Public Prosecution of the Federation, DPPF, Muhammad Abubakar, that's talking about the prayers now, of the federal government, the government ordered the court to grant its appeal and set aside the Court of Appeal's judgment. It further prayed to the Supreme Court to restore the charge against the IPOB leader for him to be tried at the Federal High Court. Now, Mr. Michael Ozekome, SAN, alright, confirmed the receipt of the filing on Thursday. You know him, he's Onyendu's lawyer. Now, Mr. Ozekome, a law professor, disclosed that he was served with a copy of the court document on Wednesday, a day before Thursday proceedings, during which the Supreme Court validated the additional filing by the federal government. Now, the Supreme Court granted leave to the federal government to update its filings with the additional grounds on Thursday. Now, the Nyango-Okoro-led 5-member panel of the court then adjourned proceedings until 11th May for hearing. All right. So the Thursday's proceedings has set the stage for the full hearing of the appeal challenging the lower court of appeals October 2022. There's the appellate court 2022 judgment that dismissed the charges against the